My name is Marsha Mavunkel, and I am one of the immigration attorneys at Swanson. Many of you may work with my other immigration colleagues, Joel Padgett, Janet Cheatham, and Amy Loyalty, who were here at some point or are here right now. And today I'm going to talk to you a little bit about U.S. immigration under the current administration. If you have picked up a newspaper or watched the news or follow Twitter, you've seen immigration at the forefront. It seems that almost daily there's a new development, a new executive order, a new tweet that completely changes the landscape of immigration. And that can be very challenging for employers and employees. When I used to tell people that I was an immigration attorney, I oftentimes was met with sort of a puzzled look, sort of what do you do? Now it seems to produce strong reactions. Oftentimes it's intrigue, other times it's maybe sympathy. But either way, I think that our job has gotten maybe a little bit more difficult, but it really is to ensure that employers and employees and individuals know how to navigate this changing landscape, and that you're prepared and informed and staying in compliance with these rules and regulations as they quickly change. Today I wanted to sort of talk specifically about a few topics that I think are hot topics right now, but also really directly impact employers. I'm going to touch on the travel ban, talk a little bit about some of the enhanced screening techniques and extreme vetting that Department of State officials do at consulates around the world for visa applicants. Also discuss administrative site visits and enforcement, which impacts employers here stateside, and I-9 very briefly, as well as some of the other developments that are less in the news but definitely impacting employers. When I was preparing for this presentation, I kind of joked with our wonderful marketing team that I don't think I can get you the slides until really the day before, because things are moving so quickly that if I give you my slides a week in advance, they're not going to be relevant by the time of the presentation. So Friday I sent off my slides, and sure enough, Sunday there was a development in terms of the travel ban. So I quickly, Monday, had to change everything. But I wanted to first sort of go through a little bit about the history of the different iterations of the travel ban with you. The initial executive order was implemented in January of this year on the 27th. It had a number of items within it that imposed sort of restrictions on numbers of refugees, totally restricted refugees from Syria, and also implemented a 90-day ban on travelers from specific countries. And there were 7 countries that were listed: Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen. Not surprisingly, this was immediately challenged, and it was brought to federal court to challenge it based on discrimination provisions, as well as whether or not the president had the authority to implement such a ban. And pretty quickly, a nationwide order was implemented halting implementation of the ban in that current state. And the ban really did initially produce a ton of surprise. We weren't expecting it. Even government officials that were meant to enforce it weren't expecting it. People were literally in the air flying into the United States that were impacted by it, or abroad visiting relatives or on a business trip realizing I may not be able to get back home. And so this initial version was, however, halted, and in response to that, the administration said, let's try again, let's carve out some exceptions and see if we can address some of the concerns about how broad this is and how little kind of guidance we were given on it. So version 2.0 is implemented. The redrafted executive order was issued on March 6th of 2017. It made some changes, such as excluding Iraq and providing some exceptions that it carved out, saying that lawful permanent residents of the United States that are from one of these countries would be able to receive waivers, and that current visa holders wouldn't be subjected to it, and that foreign nationals who were already in the United States, were admitted or paroled, wouldn't be subjected to it. But again, not surprisingly, it was challenged once more, and the Hawaii District Court issued again another order halting implementation of version 2.0. So rather than trying to redraft and come up with a new version, this time the administration decided, you know what, we're just going to go ahead and challenge this right up the ladder. And so they decided to take this to the Supreme Court of the United States to determine whether or not they could implement this. The Supreme Court accepted that and set a hearing date for October 10th of this year to hear oral arguments on it. In the interim, they decided they would allow for sort of a limited version of the ban to be implemented, and they provided some guidance on what those exceptions were, and those included individuals that had a bona fide relationship with either a person or entity in the United States. For sort of a definition of who has a bona fide relationship when it comes to family or close family, they give us very specific guidance. Initially, it was parents, in-laws, spouses, children, siblings, and later they included fiancés as well. This was again challenged, saying, well, what about extended family? We consider them close as well, and that was additionally included in the definition. For businesses, it was a little less clear what that meant. What they did say is that the relationship should have been created, in the ordinary course of business. It should be formal, documented. Essentially, we saw that it was possible for people that might work abroad for entities that were related to U.S. employers. They were able to come in because that was sort of an established relationship already. And if we were able to provide that sort of documentation of that prior relationship, we were able to bring in business visitors to come into the United States. But it was a little bit vague, and it's still been something that we sort of interpret on a case-by-case basis and try to prove. So this is what we had to deal with for a while, and then Sunday we were provided with a new definition of what the travel ban is, and that's because that was the date that the 90-day period expired. And during that period of time, the U.S. government's goal was essentially to conduct a worldwide review of information sharing practices with other countries and establish whether or not we were satisfied as far as our national security goes with how they were vetting individuals. And they looked at things such as whether they were using a secure biometric process for passport issuance, whether they were providing us with information on any terrorist activity or criminal history for individuals. And so based on this information, they decided to do more of a country-specific targeted approach, and they came out with 8 specific countries who are now on the travel ban list. So what was released on Sunday was a presidential proclamation, and it is the version 3.0 of the travel ban. The proclamation enacts a ban that excludes individuals from Chad, Iran, Libya, North Korea, Somalia, Syria, Venezuela, and Yemen. Implementation is going to be sort of a phase-in process, and so ultimately the full restrictions will be implemented as of October 18th, but they're kind of doing a 2-phase approach to this. The proclamation will apply immediately to those who are covered by version 2.0 of the ban, and who lack that credible bona fide relationship that we discussed earlier with a person or entity in the United States. And so that went into effect immediately on Sunday. The second sort of phase of it is to broadly apply it to the 8 countries listed. So all countries who, Iran, Libya, Syria, Yemen, Somalia, and then the new countries that were added, Chad, North Korea, and Venezuela, the new ban becomes effect on October 18th. And notably, Sudan has been removed from the original, or the version 2.0 6-country list. So that bona fide relationship exception will exist for those 6 countries until October 18th, and then the new implementation will go into place. And then we did put out sort of what the specifics are for each of the 8 countries. You'll see that for example, North Korea and Syria, it's sort of a blanket ban on immigrants and non-immigrants. Entry in either of those categories is suspended, while other countries, you'll see there's a little bit more of an exception for certain non-immigrant visa categories throughout. So in terms of, are there any exceptions to this? Are there any waiver options for individuals? There is a waiver option. It is fairly broad in how it's interpreted. Essentially, the waiver applies to individuals who it would cause the foreign national undue hardship, and their entry would not pose a threat to national security or public safety, and would be in the national interest. And of course, it would be up to the consular officer to determine what that in fact means, and consular officers are given very broad discretion in their interpretation. There's also case-by-case waivers that will be implemented, not categorically, but based on an individual case-by-case basis. And there's a series of factors that these consular officers will consider. Exceptions can be made for urgent medical needs, those employed by the U.S. government, and those traveling with specific purposes, significant contacts to the United States, and we'll provide some of those exceptions in our handouts, and those items will be available on our website. So in keeping with sort of what's happening abroad, the other thing that we've seen is implementation of enhanced screening and extreme vetting by the Department of State. So that means that when somebody goes to obtain a visa to enter the United States, they have to go to an interview with a consular officer, fill out a non-immigrant visa application form or an immigrant visa application form if it's for a permanent benefit, and disclose certain information about themselves. What's happened now is the Department of State has obtained approval to include sort of a new supplemental questionnaire. It applies to individuals that they categorize as having been determined to warrant additional scrutiny in connection with terrorism or other national security-related visa ineligibilities. Again, how is that determined? That's usually done by the consulate, by Department of State. For those of you that employ individuals on non-immigrant visas, you're probably familiar with administrative processing, which is another way in which the government has oftentimes conducted additional background screenings and checks when people go for visa interviews. There are multiple things that can trigger this. It can be that they just share the same name as somebody who is already on their watch list. It can be based on their skill set, their educational background triggers a red flag. But when it is subject to this additional screening, it oftentimes then goes into sort of the FBI or Interpol doing these background screenings to ensure that they don't pose a threat to our national security. This is a different process, and it takes what they've already been doing with the DS-160, the form that individuals already have to fill out, and increases how deeply they're digging into their background history. And I've put out sort of the bullet points that they have disclosed to us that they'll ask for, including travel history during the last 15 years, including source of funding. I mean, I'd be really impressed if any of us in this room could remember our travel for the last 15 years and how we paid for it. It's definitely a significant increase in scrutiny and information. So moving to sort of what's happening stateside, we are continuing to see a culture of compliance, and that means that enforcement is a really big issue. And we see that quite often through these administrative site visits. And these administrative site visits are part of a directorate, the Fraud Detection and National Security Directorate, with the mission being to protect national security and prevent immigration fraud. This started with the H-1B program. The H-1B is a type of non-immigrant visa, and it is for positions that require degree professionals, what we call specialty occupation positions. And the program, for those of you that employ individuals that have an H-1B or an L-1, you may be familiar with the $500 fraud fee. That goes directly to funding this administrative site visit and verification program. And it's immigration's way of ensuring that what you put in these petitions and these applications that you submit to the U.S. government, you're actually following through with it. You're paying the wages you're saying that you're paying. These employees are sitting at the locations that you're saying that they're sitting at. They're doing the job duties that you've gotten approved by the government for them to do. And that's what these site visits basically try to verify. There does seem to be certain industries that are targeted, and high-tech, and industries that perform sort of outsourcing seem to be targeted. And oftentimes that is because, in these, especially with outsourcing, we're seeing employees being placed off-site, maybe not with the employer, but at a client site. And so it's the government's way of ensuring that there's not these job shop situations happening, that employees are actually working for these employers. The need is with the employer. We're not trying to do staffing agencies, and that they're complying with the labor condition application and wage requirements. Traditionally, we've seen this with H-1Bs and L-1s, which is the intercompany transferee visa for managers and specialized knowledge employees, where a company might have an affiliate or a related legal entity abroad, and they bring over an employee to their U.S. operations. And we're seeing that there are more site visits happening for that category now, where previously it was really concentrated on the H-1B program. We're also seeing this has now been expanded to include STEM. STEM is science, technology, engineering, math students who participate in the optional practical training program. And that means that when they graduate, they're allotted a 1-year work authorization, and then for individuals that are in the STEM category, this STEM field, and work for E-Verify employers, they're allotted now 24 months of additional employment authorization. While the government gave us additional time, it used to be a 17-month program, they also have cracked down on sort of the requirements for the program, and that includes adding these site visits to ensure that these students are getting the training, that there is now a form where you have to disclose what the training is and how it relates to their degree programs. And so these site visits now have been expanded to include the STEM program as well. So what happens during this visit and what should you expect? As I mentioned, essentially we're just trying to verify that what you've said in your applications and your petitions is actually happening at the place of employment. Most often it will be unannounced. For H-1B and L-1, it is typically unannounced that a immigration contractor will come to the place of employment unannounced and say, I'm here to see this beneficiary and I'd like to speak to their supervisor or whoever signed the actual petition. And they are there to verify the items we discussed: workspace, are they at the physical work location, are they working the hours as they said, are they getting the salary and doing the job duties. Oftentimes the official will document, take photos of the work site, ask to review immigration documentation, and certainly want to speak to the employee and their supervisor. If all goes well, the best news is that you won't hear from them again. There's no sort of good job. Rarely is there sort of a good job. You're doing well. If there is a reason why the employee or the employer who signed the documentation isn't there, oftentimes they will just say, like, let's complete this process through an email or through a phone call. You can send me the documentation. We need to verify that the employee is doing what they need to do. Worst case scenario, if they're completely not doing what they're supposed to be doing, or they're not on site, or there's been a significant material change that hasn't been reported, there is a possibility of revocation of the petition itself. And luckily we haven't seen a lot of that with the clients we work with, but it is why we are so annoying about making sure that individuals are where they say they are working, and we're always double checking with our employers that there hasn't been any change to job location or duties or salary. So I also wanted to provide just some best practice steps. Don't panic. Make sure that both the beneficiary and the employer are aware of what was put in the petition. These petitions are approved oftentimes for a 3-year period, so you're not looking at them quite often. You're not thinking about them. But it is important to kind of keep up on it, make sure that changes are reported to your counsel so that we can take the appropriate steps. Make sure that the signers and the beneficiary are aware that these site visits can happen, and don't be worried. It doesn't mean that you're in trouble. Oftentimes they're random. Sometimes they are due to some sort of complaint, but it doesn't mean that you're going to be in trouble. If the individual who typically signs or is aware of it is out of the office, make sure there's a backup, that there's somebody that knows what to do in this circumstance. And the receptionist is oftentimes your first line of defense when it comes to this. They're the first person that's going to talk to this officer, and they should be aware of what to do. Get a card, make sure you have contact information. Put them in a conference room where they can wait to talk to the employer or the employee. Just make sure that they're aware of what those steps are that they can take. And then just make sure you have the files you need on site. For certain visa categories like H-1B, there are requirements to maintain public access files at either the employer's principal site or the actual work site. So just make sure that those are where they're supposed to be. I just wanted to briefly touch on Form I-9. This can be a whole talk in and of itself, but I wanted to just remind everybody what I-9s are, and hopefully everybody's using them. They are used to verify identity and employment authorization, and all employees should complete them. The newest version of the I-9 was as of September 18, 2017. All employers in the United States should be using this newest version, which has an expiration of August 31st, 2019. And this new version is what they call sort of the Smart I-9, and that means that basically immigration has added what is kind of really fancy for USCIS, which drop-down menus and things of that nature to reduce errors on the I-9. There is an increase in audits that hasn't stopped. This culture of compliance continues to be a priority for this administration. That is seen in more I-9 audits and more site visits. And I also wanted to remind everybody there was an increase in fines, the fun part of I-9, which I've included sort of a chart showing the penalty as it was and what it was increased to on August 1st of 2016. It's notable that there were significant increases for technical violations, which are usually the easy stuff, mistakes or omissions that we can pretty easily correct. But you'll see that there was a 96% increase in these fines. So it is substantial. This is still a focus, and just be aware of that. So just finally, some points to touch upon. They're not in the headlines, but they're certainly relevant to employers. There have been some new requirements made, and I just wanted to point out a few that I think are important. Interview requirements for employment-based green cards. They are now required for all employment-based categories as of October 1st. And this is, it wasn't that it couldn't have happened previously where employment-based green card applicants were asked to come in for an interview, but most typically they were waived absent certain issues that would arise. This is going to put in a huge influx of interviewees into an already backlogged system. So we expect there to be significant delays in issuance of green cards moving forward. Also, for those of you that employ H-1B employees, premium processing, I know there's been a lot of concern about when this will come back, and premium processing is the government's expedite option for getting a decision on an H-1B application, and it's guaranteed within 15 days if you file it with this additional $1,225 fee. This was suspended during tax season, which is when the annual quota opens up for H-1B petitions. And there is an 85,000 max, and it is every year now well exceeded because of this really large overload of H-1B petitions. Resources are limited, and they've suspended the guarantee that it would be adjudicated in a 15-day period. We've all been anxiously waiting for this to come back, and they've slowly been phasing it back in. They started by allowing CAP-exempt employers, such as institutions of higher learning, to start using it, and then we thought October 1st it would be provided to everybody else, but they've limited it to just CAP cases, so those that were subject to those current CAP. So you can intra-file them if you have any H-1B CAP cases that haven't been approved yet. And then just generally, we've seen a really big increase in requests for evidence and denials, and that's sort of across the board. It is definitely a priority of this administration to kind of focus on employers proving a little bit more robustly that individuals qualify for these types of applications. We're seeing a huge uptick, especially with CAP cases, and it's sort of an ongoing process as to sort of how we're dealing with these increases, and even at a national level that's being addressed. There are a number of things I didn't talk about in today's presentation, including things like what's going on with NAFTA. And that's really because there's nothing happening right now that we're aware of. And of course, it's in the news constantly that there will be some changes. We haven't heard of anything that will impact sort of the immigration components of it, such as the TN visa or a number of other provisions within it. There's also other things such as the Deferred Action for Childhood Arrival, the DREAMers Act, and those are large topics in and of itself. I'm happy to talk to you about it after this presentation during our cocktail hour. But those are all on our radar, and we try to regularly alert our client base and about any changes that may occur.